Hi, everyone. Welcome, everyone, to this important panel discussion titled From Institution-Centered to People-Centered, Redefining Justice in the Criminal Justice System. My name is Ferenza Wadamal. I hope you're familiar with me by now, and I have the honor again to serve you as the moderator for this session. Today, we gather to address a pressing issue, the urgent need for a transformative shift in our criminal justice systems. Traditional approaches often prioritize institutional objectives over the needs of individuals or the customers of the justice system, like I like to refer to, leading to systematic inequalities and barriers that undermine public trust. As we explore this topic, we will consider how a people-centered approach can enhance accessibility, fairness, and responsiveness within the criminal justice framework. Our discussion will focus on several key areas. The role of stakeholders. We will examine how police, judges, civil society organizations, and other stakeholders can implement a people-centered framework that addresses the unique experiences and needs of diverse communities. Successful initiatives. We will showcase successful initiatives from the Asia-Pacific region that exemplify this shift toward inclusivity and equity in justice. Third, we will recognize challenges and also opportunities in implementing people's justice in criminal justice system, as we recognize the challenges that exist as well as the opportunities for necessary changes that can lead to meaningful reform in our justice systems. The goal of this session is not only to highlight these issues, but also to inspire a vision for an equitable justice system that truly serves its communities. I encourage all of you to engage actively during our discussion. Your insights and questions are invaluable as we work together towards achieving SDG goals, particularly the Goal 16, which advocates for inclusive societies. Without further ado, let's begin the discussion. We will have 2 rounds of questions, followed by a Q&A, hopefully if we have time. I will introduce our esteemed panelists one by one as I pose questions to them. In the first round, we will focus on successful cases of implementation of people-centered approaches in different branches of criminal justice. Today, we are privileged to have panelists representing perspectives from the upstream of the system, like the police force, the critical middle stream, like the judges, and the downstream, like the reintegration process. Let's begin with our first speaker. Eko Novan Prasetyo Paspito, Chief of Supervisor Investigation, CID Central Java Regional Police from Indonesia, and an investigative interview expert. Eko, how can people-centered approach in investigative interviews effectively balance the rights and needs of both victims and accusers while ensuring a thorough and efficient fact-finding process?
Bismillahirrahmanirrahim. Good afternoon, ladies and gentlemen. I am pleasure, honor, among to be important people here. I am Eko, and today I will be tell about my experience on my journey facilitating training and implementing investigative interviewing. Maybe we call about maybe we can call the people center in investigative interviewing. Before I talk about investigative interviewing, I will tell shortly about investigative interviewing. Investigative interviewing is an interview technique for the witness, suspect, and a victim. Investigative interviewing is using a PIS model. PIS model is acronym from planning and preparation, engage and explain, account, clarification, challenge, and evaluation. The objective of investigative interviewing is get a reliable and accurate information from the interviewee, not obtain the confession. The The investigative interviewing is a method, a technique to prevent violence, torture, coercion, manipulation in interview process using by interviewer. When we talk about investigative interviewing and we talk about people center, a people center approach, it's part of investigative interviewing technique. Investigative interviewing technique about balancing the need of individual involved in justice process with the goals of accurate and efficient investigation. I will speak maybe 4 points about it. The first is about 4 core elements of investigative interviewing. The second is a transformation while we implementing investigative interviewing. The third, the development and impact of a investigative interviewing room in Wonosobo, Resort Police Office in early 2023. And the last is about strategy, investigative interviewing, and people center. The first, when we implementing investigative interviewing, there are 4 core elements to make investigative interviewing effective and people-centered. This element guide interview in creating respectful and productive interaction. The first is respecting a people. In investigative interviewing, we approach interviewee with a respect regardless of their role in the case, whatever they are, whoever they are. Can be a victim, suspect, or a witness. The respectful approach is not only encourage cooperation, but also foster individual feel heard and value. The second element is a building rapport. Building rapport is about establishing a connection with interviewee, interviewers, situation. Create a trusting space. This often leads to more open and truthful communication. Sometimes I meet a cooperation or non-cooperation suspect, but I must uphold building rapport, whatever they are, whoever they are. The third is to be applied, not just discuss. Investigative interviewing principles are designed for practical application. This is not just theory. When we train officer investigative interviewing, it's not only about the concept of investigative interviewing, but to apply them directly in a real case. The goal is to ensure that this principle become a part of everyday practice. The last element is gaining benefit. People-centered or investigative interviewing approach ultimately benefit everyone involved. For the interviewee, it ensures they are treated fairly and respectfully. For the interviewer and the broader justice system, it leads to more accurate, reliable information and strength public trust. This element provides a strong foundation for a people-centered justice in investigative interviewing. Now, how about transformation supporting people-centered justice in Indonesia? Based on my experience, I have seen how adopting investigative interviewing has transformed but the mindset and the skill set of the officer. The first is mindset shift. Investigative interviewing encourages shift from traditional and confrontation learn and confrontation mindset to one focused on understanding and truth finding. Such a mindset shift is a fundamental in creating a culture of justice that is truly people-centered. The second is improve interviewing skill. The training investigative interviewing equip officer with advanced skills. They learn to ask open and ended questions, active listening, engage an interviewee, and in way that prioritize respect and objectively. This skill not only improve the quality of information gathered, but also contribute to more ethical and professional justice process. The last is promotion of evidence-based approach. Investigative interviewing is built on research-backed method for gathering information. By relying on this evidence base, we ensure that information is collected in structured, fair, and consistent manner. This minimizes bias and error, leading to more reliable outcome. Through this transformation, investigative interviewing has greatly contributed to build a justice system that is focused on a people itself. For the last, the investigative interviewing is based on evidence, not just a confession. We know the junior detective, sometimes he obtain a confession. What is the impact? It will be a false confession. The false confession can make the false decision maker. And the last, it can make the false punishment to a suspect. And we know after that, it will be increase the public trust. Thank you. It's finished. And after that, I will, for the session 2, I will tell about investigative interviewing implementing at our office.
Okay, thank you very much, Echo. It's very interesting how you shared about the core elements of investigative interviews and how this strategy or how this framework is used to make the investigation more people-centered. Next, I would like to turn to Judge Dantanom Sirivat, Senior Judge and Chief of the Commercial Chamber of Laos BDR. Judge Sirivat played a pivotal role in combating trafficking in persons cases and developing First Laos Victim Sensitive Courts Guideline. Judge Sirivat, can you tell us about the Victim Sensitive Courts model and how it enhances the rights and experiences of victims during legal proceedings with a people-centered approach?
Okay. Good afternoon, everyone. Thank you, Khun Phuong. First of all, I would like to express my sincere thanks to organizer for invite to be the panelists to share on the practice of people-centered approach in Lao court. One more time, my name is Jantanom Silivat. I am a judge from the People's Supreme Court in Laos. I have experience working on criminal, civil, juvenile, and commercial cases. I believe that my diverse experiences and knowledge will be valuable to everyone here today. I am excited to share some initiatives regarding the people-centered approach adopted by the courts in Laos. This initiative represents the first guidelines of kinds in ASEAN and Laos. It's the pioneering country to endorse these guidelines within its local context. Why do we need this guideline in Laos? I would like to begin by discussing the background of the victim-sensitive court guideline developed by the Lao People's Supreme Court. This guideline makes a significant transition from an institution-centered to a people-centered approach. As you are aware, Laos has ratified the ASEAN Convention against Trafficking in Persons, especially women and children, or ACTIV for short, and has established national laws to align with ACTIV. Both ACTIV and Lao national laws outline the rights of victims, particularly their rights to legal services and other programs. Recognizing the importance of victim rights during court trial or consideration, a victim-centered approach is required to place victims at the center of consideration when performing their judicial tasks, emphasizing practices that effectively address the protection of victims from further harm. The Lao People's Supreme Court will support from ASEAN Act, developed the Victim Sensitive Court Handbook. This handbook outlines victim rights with the victim-centered approach, ensuring enhanced rights, particularly regarding safety, privacy, confidentiality, compensation, expansion from criminal liability, and closed trial to protect their dignity and safety. The court reinforced these rights in accordance with the law. In the court, we provide a waiting room and interpreter if need. We have measures in place to avoid confrontation between the victim and the defendant or others involved in the case. Victims also have the right to choose their legal protectors or lawyers, selected the gender of the judge to ensure their comfort during legal proceedings, and decline to be present at the court hearing also. Keep case file and all information of the victim confidentially. Automatic decision before making them publicity. For child victims, the judge will not wear a just robe, and the courtroom environment is made more child-friendly. During the court trial, the judge used their skills to interview or question victims with the softer tone and simple, easy to understand language. This approach aims to create a friendly atmosphere, helping victims feel more relaxed, trusting, and safe. And in the context of the, oh, sorry, that's all for first question.
Thank you so much, Judge Sriva, for sharing with us the pioneering victim-centered guidelines that not only ensure that the victim rights are protected during the judicial process, but also make sure that they are comfortable and feel emotionally comfortable throughout the process as well. Our third speaker is not a traditional player within the system. Madhurima Tanuga is a criminal justice reform expert from India who has 16 years of experience in the field. I think we can all agree that to reform the criminal justice systems, it cannot only be done with players within the system. It requires collaboration between stakeholders, both from within and from outside the system. Madhurima, as a criminal justice reform expert operating from the outside the traditional justice system in India, how has your perspective contributed to making prison reform more people-centered?
Yeah, thank you for the question. A very good afternoon to everyone, and I extend my gratitude to the conference organizers for having me here and asking me to share my experience being a non-traditional player in the field. So as Fern has said, I've been working on prison reforms in India for the past 16 years. My journey of intervening in prisons, it actually started as a law student when, as part of a summer internship program, we were taken to one of the largest prison complexes in Asia, which is in Tihar Jail. And as a law student, I think, going to prison is itself a very humbling experience. But the first realization that strikes you is that prisoners are people, right? And which is usually not the case because, you either have a vision of prisons from what you see in the movies or, it's very different from outside. And then when you go inside, when you talk to them, when you interact with them, and you understand, the prisons from their eyes. As life moved on as a lawyer, we started to understand, how important it is to talk to the client, to know what they feel and what they want from the case, what is their perception of what they want. But then when I started working with this organization called the Commonwealth Human Rights Initiative and started engaging in advocacy with the stakeholders, we came to know that, prisoners' experiences were not, taken in account of. We looked at it from the institution perspective. They were more interested to see that, pendencies are not there. They were interested to look at how it reflects on the institution. So then slowly we decided, we started doing a bit more of research. We started a legal services clinic in a prison. We started interacting with prisoners. And when we started interacting with the prisoners, we came to realize about their daily problems, their issues with the law, the legal system, the issues with the conditions of detention and other conditions. And then those interactions, when they spread across different prisons, we realized there's a pattern. It's not that it's a single prisoner facing something. There are many prisoners who are facing similar problems. So we started documenting those experiences. We started looking at the patterns, looking at the data, looking at analysis, and then, then we came to conclusions about what the system needed as an outcome of what people wanted, what the prisoner wanted. Not even the prisoner, their families, what was their experiences, what is it that, they were missing, was it the food, was it the, access to a lawyer, was it the time that they're spending inside. So we started documenting those, which was not really done before that. There've been a lot of studies which are like very overarching studies. You pick up a topic and you write about it. Like if you look at prisons, it's like a world of its own. So you had like a lot of these very broad, big studies, but then they didn't really focus on the smaller things. So that's something that we thought, kind of what seemed to be important to us. So what we did after that, we made a lot of interventions which were based on these specific instances that we found. And some of the key ones I wanted to share today. So one of the instances was, of course, that prisoners do not have access to lawyers. So what do? So there is a legal aid system that wasn't as functional as it is now when I had first started. When I first started, the first, I think, prison I visited, the legal aid services clinic was basically just a board. And when I asked where are the people, there was nobody. So a judge came, they opened the system and they opened a clinic and that's it. There's a room, there's a lock and there's a board. So we slowly realized, okay, this seems to be a problem. So we started working on getting lawyers to the prison, to get paralegal volunteers to the prison. And then today we documented, how was the experience of prisoners accessing legal aid as part of a national report. And today we have prison legal aid clinics in every prison in the country. I've been now working with the Legal Services Authority as well. I'm consulting with them and trying to streamline how it is functioning based on the experiences I have heard from prisoners, right? Like, when they complain that, okay, paralegal volunteers ask for money, or they complain that we cannot access the clinic if it is based inside the prison, if it's based in the office area of the prison and not inside the prison. So we've tried to use these experiences that we gained from them and effectuate policy reforms to address those needs of the people that we heard from. Similarly, we were doing studies on prisons, prison conditions, and we came across the issue of menstrual hygiene for women prisoners. That was something that we didn't really think of earlier. But when we started talking to women prisoners, we realized that they have probably the only thing that we think of when we talk about menstrual hygiene is access to a sanitary pad. But then when we looked into it deeper, we found that even disposal, what about disposal? What about pain management? What about their own understanding about menstruation? What happens about that? Because 80% of women prisoners are actually menstruating. So those issues we started looking at. So we looked at that. We prepared a recommendation guide. We started engaging with the departments. We started engaging with local Rotary clubs to give at least the basic elements of a disposal bin with a lid, sustainable sanitary pads. So we did those kind of things. Similar was our experience with another issue which is pretty important, is with foreign national prisoners. So we found a lot of individual cases. They were not being repatriated. They had some other issues that were, really making it difficult. Like even cases where, prisoners had been there for more than 2 to 3 years to 13 years as well, but they were not being repatriated. We started working individually. Every case was different. Something was there, but eventually we also found that, yes, the policy also had gaps, which is why people were experiencing these kind of delays in their repatriation. So we prepared a national study on that. We advocated with the departments, and we got some advisory, some guidelines that were issued, trying to address some of the gaps that were there. So this is some of the important, I think, interventions that we make based on the experiences we gained from the prisoners' perspectives, what the prisoners had informed us, and how we really tried to look at not just prisoners' experiences, but we've also tried to look at experiences of prison officers, judicial officers, police officers, looking at people in the system, because they're also people who are the functionaries. And they also had their experiences of their own issues that they were facing. And we've consistently tried to use those experiences in our interventions so that we address the system as a whole. And because when we do that, that's when you get to sustainable reforms. And that's like one of the primary things you do as a non-traditional player. You're looking at sustainability. You're looking at initiating something which doesn't fall if you're gone. It has to be something that's there even if you're not there, right? So that's kind of, how we've tried to ensure that. And I think it's really important that we do champion, the experiences of people, their needs, what they want, how they are experiencing, because, their sense of justice might be very different. Like another example one could share is we talk a lot about quality of lawyering, quality of legal aid services. And for a lot of people, quality means just winning the case. But then for a person, it might not be. For a prisoner, quality means that the lawyer actually came and talked to him. The lawyer told him at every moment what they were doing in their case. So, that kind of perspectives, it has to be seen from the point of a person and not otherwise. So, yeah, I think that's all I had on this point, that, how we should really champion as non-traditional actors in this work. Thank you.
Thank you, Madhurima. That was very, very interesting story on finding out what's really matters to the people that we are serving, in this case are prisoners, and to be able to address the gaps with interventions based on those experiences. I think when Madhurima talked about the menstrual hygiene case, that is very, very clear, because it's not just about giving them the products to help them take care of themselves, but also about disposing those products, pain management also, and the understanding about what's happening to their body. So very interesting. Thank you so much. Up next, I would like to invite Judge Taylor, who is acting presiding judge of the Regional Trial Court BR 53 in Manila. Judge Taylor's focus is on cases related to drug offenses. With your expertise, Judge Taylor, can you tell us what has been the Philippines' journey in its approach to drug offenders towards a people-centered strategy which provides effective alternatives to incarceration and enhances reintegration?
Thank you, Fern. First, I'd like to clarify that I'm the presiding judge of the Regional Trial Court, Branch 31 of Manila, and I hold another job, acting presiding judge of the Regional Trial Court, Branch 53, Manila. And these courts are both special courts designated solely for drug cases. So I eat drug cases for breakfast, lunch, and dinner. Now, the Philippine journey about our approach to drug offenders spans 50 years. And of course, it's highlighted by our very famous or infamous former President Duterte during his famous and infamous drug war, or the war on drugs. Now, in 1972, Congress enacted the Dangerous Drugs Act of 1972, wherein it imposes stiff penalties for imprisonment, and this law was enforced up to 2002, during which plea bargaining, a procedure wherein drug offenders were allowed to enter a plea of guilty to a lesser offense in exchange for a dramatic exchange in the period of imprisonment. Hence, this is an alternative to incarceration. However, this process, which is a judicial process, was abused by the drug offenders, because as soon as they are released from jail, they would go back to jail, to their drug addiction, hence would fall back into relapse. And so, 30 years thereafter, Congress enacted RA 9165, which was to repeal RA 6425, and this imposes much higher penalty of imprisonment. And what is important for 9165 was that Congress included Section 23, and this prohibited the plea bargaining process in all drug cases, because Congress, they were angry at all the drug offenders. So, but however, this was a very big mistake on the part of Congress, because instead of determining what went wrong with the Republic Act 6425, instead what Congress did was to blame the plea bargaining process, which paved the way for alternative to incarceration, and that is a lesser number of years to be served by the offenders in the jail. Now, because of this, those convicted under RA 9165 suffered prolonged incarceration. You could only imagine possession of mere 0.0000 gram of shabu, and I'm not joking. I had chemistry report 6 zeros. Their weighing scale was sensitive to that, and the penalty for now, 12 years and 1 day to 20 years. So, because of this, the Philippines experience extreme jail congestion in the entire country. Just for example, Manila City Jail male dorm was constructed to house only 1,200 inmates. But during the height of the Duterte administration, we had about more than 6,000 inmates. And the condition inside the jail is really terrible and inhumane. Now, in 2017, during the height of the Duterte administration, the Public Attorney's Office filed the People versus Estipona case, questioning the constitutionality of Section 23. And in 2018, the Supreme Court ruled with finality that Section 23 was unconstitutional, being an infringement on the exclusive rulemaking power of the Supreme Court, as as stated in the Constitution of the Philippines, meaning only the Supreme Court can issue rules of procedure such as plea bargaining. Now, because of this, hence plea bargaining was again allowed, and this process drastically reduced the penalty of imprisonment for drug offenses, thus an effective alternative to incarceration, because in the plea bargaining framework that was issued by the Supreme Court, wherein we are to allow drug offenders to enter into to plead guilty to lesser offenses. For example, for simple drug possession, it should be 12 years and 1 day to 20 years. Now, we can give as low as 6 months imprisonment and 1 day. Now, so because of this, however, the Supreme Court imposed a condition that the drug offenders must undergo a drug rehabilitation program. And this people-centered strategy is in fact the very solution that was needed, not only to dramatically decongest our jails nationwide, but also it started the implementation and institutionalization of the drug rehabilitation aftercare and reintegration program model. Now, just to have an idea when I talk about the cases, prior to the Duterte administration, our regular monthly caseload would be 30 cases in a month. But during his time, I had 160 plus cases in a month. So if you do the math. Now, because of the implementation of the plea bargaining framework that was imposed by the Supreme Court nationwide to all the drug courts, the focus is now on the drug offender, not as a criminal, but as someone who needs, who is suffering from a recurring mental disease, as defined by the UNODC, who needs intervention, treatment, and the care of government, of course, everybody in society as a whole, and including the empowerment of all these drug offenders to have livelihood to support themselves. So, truth to tell, the real catalyst in the shift in the focus to drug rehabilitation, the focus as a people-centered focus to the drug offender, instead of incarceration, was brought about not by the infamous war on drugs by former President Duterte, but rather it was the proactive stance of the Supreme Court justices when they not only struck down Section 23 as unconstitutional, but imposed a condition of rehabilitation, knowing fully well what happened in the past with RA 6425. Now, as we all know, prolonged incarceration does not work. It does not work in the treatment of ordinary criminals. And what works is a feasible, doable drug rehabilitation program that encompasses not only an aftercare program, but also a livelihood program, because in the Philippines, 90% of criminal cases are drug cases, and 90 to 95% of drug offenders are the poorest of the poor. If you are not able to give them livelihood or empower them to have livelihood for themselves, to support themselves and their families, then the entire process will not work. Now, I would like to be able to expound on the rehabilitation program during the second round of questions, because our time is very limited. Thank you very much.
Thank you, Judge Taylor. Thank you for sharing with us very, very interesting case from the Philippines that shows what happens when we don't tackle the root cause of the problem and how it backfired, and sharing the crucial role also of the Supreme Court of the Philippines to turn the situation around and reshift the focus to the drug offenders. For our last speaker, I'm going to come in full circle as I introduce someone close to home, Ms. Chontit Chunora, Director of Office for the Bangkok Rules and Treatment of Offenders from Thailand Institute of Justice. For those who may not know, TIJ was established about 12 years ago to be an implementing organization for the United Nations rule for the treatment of women prisoners and non-custodial measures for women offenders, or the Bangkok Rules. While we've branched out to work on people-centered justice, the rule of law, justice innovation, just to name a few, the Bangkok Rules still remain at our core and relate to all our other areas of our work that I mentioned. Ms. Chontit, can you please share with us how the Bangkok Rules framework utilizes a people-centered approach to enhance the lives of women in prison?
Sure, Fern, and thank you very much for the opportunity to join this panel discussions. I would like to, before I answer your questions, I like to highlight a little bit that prisoners are sometimes referring to as the forgotten populations. And when today we talk about people-centered approach, I think it is very important to identify who are the people that we are talking about. And I think in my opinions, there are at least 4 distinct groups that we could highlight. First is the primary one is the incarcerated individuals. And next is the correctional staff, the family of those incarcerated, as well as the last one, people in the community at large. So when we talk about prison and prison reforms, we must not forget that there are so many people within this process, and it's not just prisoner. But with the limited time that I have today, I must just to focus on women that are in incarcerations. Historically, as we know, prisons were designed for men and young men, physically fit men, and you could see that men have long made a majority of the prison populations. Today, we have over 11 million people in prison around the world, and there are only 6 to 9% that are women. So over 90% are men. So the systems and the prison design and regime was built around the needs of men. And that was reflected in the physical securities, the system of control, preventing of escape, and so on. So in the past 2 decades, we have seen that women in prison start to rise at the faster rate as compared to the male counterpart. So their needs were, long before the Bangkok Rule was adopted, it was overlooked. So today, with the Bangkok Rules being adopted, and next slide, please. And the Bangkok Rule, as Fern has kindly mentioned, is the first international standard and norms adopted by the UN General Assembly in 2010 that focus specifically on the needs of women in prison. And the people-centered approach that was used during the developing of the rule was reflecting in the way that the rule was developed based on evidence-based research and research around what works for women. So all those issues was put together, and the rule was designed by the experts from various countries and region. So instead of treating all men and women in prison the same, this rule challenged prison institutions to take a more people-centered and gender-responsive approach and understand what lead women into imprisonment, challenges that they face because they're not like men, and also the problem that they face after release. Just to give you some facts about women who come in conflict with the law usually for non-violence and serious offense. Majorities come to prison for property crimes or drug-related issues. And their crimes are very much rooted in poverty, a lack of education and employment. And the fact about women prisoners is that the majorities of them around the world, they are primary caretaker of their family. They are mothers. Like in Thailand, 80% of women are mothers. So when we decide the systems, a correctional system that respond to the need, we need to understand and empathize and understand the role of the mother who end up in prison, just trying to feed children and keep them alive. So the rules has highlighted the importance of keeping the family connected, how women and children can stay in a meaningful contact, how children who sometimes grow up with their mother in prison can be in the safe environments. So the rules highlight, these individuals and specific groups of prisoners' needs. And moreover, most prisoner, one point that are so different from men is that most women's prisoner come with the history of trauma. And often it's caused by history of being victims of domestic violence, sexual abuse, or other forms of victimizations. And without recognizing these histories of victimizations, prison will not be able to provide and respond to the needs of these groups of women. So the Bangkok Rule has highlighted this important aspect and call for the trauma-informed care, understand what are the cause of trauma and how to respond to trauma. And by not using force or fear or authoritarian management style as prison used to do. And I think this concept of dynamic security, similar to what Echo has mentioned about investigative interview, dynamic security, not just focus on physical security, but how prison can build a positive relationship with the individuals incarcerated and to understand their background, understand their needs and situations. And that would help prison to identify, anticipate risk, and mitigate a risk of safety and security in prison. So these are some of the key factors that was highlighted in the Bangkok Rules. And finally, the people-centered approach of the Bangkok Rules also evidence in their recognitions of diversity within the female prison populations. Obviously, when we talk about women, we are not homogeneous. In prison, we have aging women, we have women from foreign nationals, ethnic minorities groups, and sometimes we do have children who live with their mother in prison. And to understand this diversity of backgrounds, as well as intersectionalities that could produce a more complex needs is really important in the work of the prison management. So I will end my first round with this, Fern.
Thank you so much, Ms. Chuntit. Very interesting as she started off reminding us that who are the people that we talked about when we talk about people in prisons is not just the incarcerated, but the people also include staff, incarcerated families, and communities at large. So at TAJ, when we talk about making people-centered justice, we not only just focus on the criminal justice system itself, but we look way beyond their journey into coming before they enter the criminal justice system, and also right after, once they get out, how do they reintegrate back into their society. So in the first round, we've heard about so many different ways how the people-centered approach can be utilized across different branches of the criminal justice system. However, while these are all amazing case studies, we still have a lot of work to do in truly transitioning the system from institutional-centered one to a people-centered one. In the second round of discussion, we will focus on lessons learned from the applications and the opportunities in taking it a step further. I will reverse the order of the first round. So I will go back to Ms. Chuntit again. Ms. Chuntit, since the adoption of the Bangkok Rules in 2010, it has been 14 years that the Bangkok Rules have been around. Can you tell us what are the insights drawn from the implementation of the Bangkok Rules and how can they inform broader strategies for prison reforms?
I think the Bangkok Rules, as well as other UN standards and norms related to prison, is all support of this fundamental shift in a way that we see prison and the purpose of prison. Obviously, prison is the largest institution for state control. It is the facilities for confinement. So with that purpose, when we see prison, when we imagine prison, we would imagine a very high wall. We would imagine high security, civilian systems everywhere, prison guard being really tough. But research has proved that punitive institutions like that would never work would never be able to reduce reoffendings and would not be able to protect people in the community at large and ensure that safety. So shifting the purpose of the prisons, meaning that we need to rethink of prison as a place for rehabilitations, a place where individuals can reflect on their mistake, can learn new skills, and then can rebuild their life and become a more productive citizens of the society again. And that means we need an individualizations in how we treat each one. We need a good classification system that take into account the many different criminogenic factors, social factors that are relevant to each one, and design the program that are respond to each individual. But in reality, that is not always possible because of the prison overcrowding is a big, massive thing, especially in the region where we are in. In many countries, prison have hold more than number than the capacity that it could really cope. So with the prison overcrowding, rehabilitations that based on the individual needs would never be a reality. So I think one big issue that we have to work together is how do we reduce the use of imprisonment and to ensure that prison can do its job properly by rehabilitate people who are coming into contact with it. However, if we need to use the prison, I think the people-centered approach can be reflected and can come as an actionable strategy in many ways. First of all, prisoners or people in incarcerations are still part of community. So it's not possible that prison would work alone. Collaborations with communities, agencies, social partners are really important. And I think it's also important to be able to discuss about prison life and reality in prison openly. You know, it should not be a myth. It should not be so difficult to talk about prison and be censored all the time, because that would keep prison away and further away from society. And how would people in prison be part of the society at large? So reduce that gap between prison and society. And secondly, I think if we talk about the ideologies of prison being a place for punishment, shifting away from that towards rehabilitation, it is also important to change how we talk about prison. Our language matter. Can we use the person-first language? Instead of calling prisoners criminals or inmates, can we focus on the person first? Can we, I think in the Philippines has been leading in this topic, people deprived of liberty. Yes, PBL. Yeah, person first, institution after or later or never. Or can we call, instead of women's prisoner, because I sometimes use that, instead of women's prisoner, can we use the term women's in corrections or justice involve women? So because those terms, prisoners or criminals or inmates, reinforce the idea of the person as defined by institutions or by circumstances that they face. So I mean, if we want to change the way we perceive prisons and the purpose of prison, we have to change from our language, and that language will change the culture sooner or later. So, and my final word would be that when we need to look at prison in the holistic view, seeing prison as not just the punitive institute, but seeing prison as a place where individual can grow and can learn and still be part of community again. Because once prisoners serve their time, they're going to be back into society. I think only then we can realize the potentials of humans in transforming their life. And I think only then we can make prison more fair and make societies more just and inclusive, regardless of the circumstances that individuals are in. Thank you.
Thank you so much, Kunchontit. Thank you for sharing the people-centered approach to how we see prison and how we see the purpose of it. And three very interesting points and very important ones to also, first on collaboration to be able to reduce the gap between society and prison and change the language, how we talk about prison and focus on people's first. Actually, words matter, right? We always talk about that. And also to see prison from a very holistic view. Up next, I will turn back to Judge Taylor. Judge Taylor, what are the roles of the judges and court in incentivizing people-centered approaches within criminal justice institutions?
Okay, judges play a very critical role in people-centered approaches because we, the judges, and I understand there are several judges here, we are the ones directly in touch with the litigants, with the prisoners. We hear them, we see them. We can even literally smell them inside the courtroom. When I say that, all you can have is empathy for the prisoners and the litigants. And so, because of that, we adopt a more people-centered approach in the resolution of the cases. Thus, I could say one of the incentives would be the more speedy disposition of cases because the judges are now in personal touch with the litigants and the prisoners and can better manage time on how to resolve the conflict and the cases. And moreover, since the judges are directly involved with people-centered approach, the net effect is a fairer and more impartial disposition of cases and its case flow. Thus, it encourages trust in the legal system and encourages the community to be more engaging with the legal system. Also, being the ones directly involved with the parties and the prisoners, necessarily judges have a more people-centered approach. And then, of course, they can better promote restorative justice practices such as reconciliation and arbitration between party litigants. And almost always, you know, when there is an arbitration process, the parties would respect that and hence reduce conflict, if not totally eliminate them. Now, judges are involved directly with the people. They are therefore able to offer alternatives to incarceration and prolonged incarceration, such as I've just discussed earlier, the plea bargaining process, and we also have probation, community service, rehabilitation programs, reintegration programs, and such other programs that are available to the judge. Now, just for a quick overview of what happened with our rehabilitation process. So after the Supreme Court implemented the people versus, promulgated the people versus Estipona case and implemented the plea bargaining framework, the judges didn't know what to do. Because suddenly we have to go into rehab. Suddenly we were converted, we the drugs court judges, we were converted as drug rehabilitation centers. So, panic mode. But luckily, down the line, the Dangerous Drugs Board came up with a Board Regulation number 7, series of 2019, which is rules on rehabilitation, which is actually patterned after the UNODC framework. And this actually is in line with the 12-point principles on rehabilitation and treatment laid down by the UNODC. Now, under that framework, the first line of defense would be the determination of the drug dependent as to what is the level of addiction, either mild or moderate, in which case they would only have to undergo counseling outside the area, so they will be released from jail. They only have to go through counseling. If they are determined to be high risk or severe drug dependent, then they will have to be brought to the drug rehabilitation center for an in-house drug rehabilitation program. However, this is only 1% of the entire population of drug addicts, even in the entire world. Then after that, after completing the counseling program, they will have to go through an aftercare program. And after going through the aftercare program, they will have to, the aftercare program rather, would include theoretically, and in many cities in the Philippines, and provinces. Of course, the more important, as I stated, is the livelihood component of the entire drug rehabilitation program. Now, I will discuss that later on in line with the projects that is being shown in the slides, but also, being at the helm of the judicial process, judges are in the best position to advocate for policy change, shifts in policies that support people-centered practices. And judges can engage in education, public awareness campaign for a more informed public. Now, also, judges are an excellent sort of ideas on how to come up with better system of monitoring of cases and the creation of doable, better comprehensive computer monitoring systems. And this is needed for speedier disposition of cases and to help secure in database statistical information, because data are needed to formulate more effective policies to better serve the needs of the people. Now, lastly, I would like to discuss, having been with the accused, in touch with them, you see them, feel them, their families would go to you, telling them all their problems. So I have, in my little way, come up with my own projects. And the first project that we had came up with is the online Bible study project that we started in August 2020 during the pandemic. And you would ask why a Bible study project, which is being conducted in the jails, because Filipinos are deeply religious. And if you really want to get into the Filipino psyche, you have to approach the problem from a religious point of view. And I could tell you it is very effective. Now, I had an experience wherein because we have to monitor our accused. It's not just we refer them to the counseling service provider, no. We have to monitor, and so I had an accused, Victor, who reported very early in the morning, and he was obviously very depressed. And I asked, what's the problem? And he said, because I don't have any livelihood, because the police took his food cart away. And that started the food cart project that I had, which I started in February of this year. And we had a launching at the Manila City Jail, and then a judicial launching at the Manila Yacht Club. And so far, the project entails my court giving to the poorest of the poor, drug offenders, food carts complete with the equipment and food merchandise, and of course the cart, which is mobile, for them to have a livelihood, to sustain themselves, to and their respective families. And you would ask, what is the incentive? The incentive is to see them being happy, being proactive, and being able to be reintegrated back to society as productive members thereof. Thank you very much.
Thank you, Judge Taylor, for expanding on the crucial role of judges in leading the people-centered approach that is not just limited to within the premises of the court. Up next, I will turn back to Madhurima, who shared in the first round on the aim for sustainability, right? Yes, sorry. We'll do Q&A after, about like 15 to 20 minutes if the time allows. So please, if you have some questions, please save them for now. If you want, write them down so that you don't forget as well. Thank you. Back to Madhurima. In the first round, you talked about sustainability, right? As someone who works with from the outside of the justice system, you focus on sustainability and aim for that to make sure that your work can continue even when you're not there. I'm wondering, how does collaboration between the traditional players like the police, courts, correctional system, and etc. within the criminal justice system and the non-traditional player like yourself encourage the transition from an institutional-centered system to a people-centered one?
Yeah, thank you for the question. So there's a motto that we've worked with from the very beginning, which goes, engage where you can and confront where you must. So the first step is to engage, because experience shows the confrontational approaches, like we're a non-traditional actor and traditional actor. If you're looking to engage, it works better than a confrontational approach where, kind of you pitch the institution against the person. It might not succeed. But a collaborative approach where you're kind of trying to convince the person, through data research, which they cannot deny, right? It is, you talk to them about the institutional policies, the way of functioning, and how those have negatively impacted individuals. You talk to them about the cases, share the case studies. They've kind of work better. So I think it's, the functionaries, we've also found in our experience that a lot of functionaries of the institutions, they are also looking at change. So not all of them, but there's always these good friends, we call them, in the system, which want some change to be there, but they're not in a position to push for that change. And they look at non-traditional players like us to push for that change. They will tell you exactly what, these are the problems, these are the solutions. And I think they are the people, who really helped us in terms of, framing interventions, nuancing the interventions, making them sustainable. So I think that's where the collaboration part of it is really important. And there is an example I want to share in terms of, how non-traditional actors and traditional actors work together. So in Karnataka, which is a large state in the southern part of India, we were commissioned to do a study, as in my organization was commissioned to do a study on prison conditions, looking at the 51 operational prisons in the state. And they took the initiatives. This was the State Legal Services Authority, which is the legal services body in India, and they also took on board the prison department. So the prison department and they were on board when we conducted the study. And the study that we prepared, it covered 15 thematics. And of the 15 thematics, 3 were focused on the world of prisons, and the rest 12 were focused on the world of prisoners. So we tried to highlight, all the issues that we came across from interviewing with prisoners on the premise of, how prisoners' experiences were being, how prisoners were experiencing the system, basically. So the study, when it came out, because we started it as a collaborative effort from the very beginning, it was really successful in instilling a lot of reformative measures in the state, which were taken either by the State Legal Services Authority or the prison department or the state government itself. Even the judiciary got involved, and they constituted a committee to look into the findings of the report, put together the recommendations, and some of the very, I think, basic things that were reflective of prisoners' experiences were orders to boost prison capacity, so building of more prisons because there was a lot of prison overcrowding, construction of toilets, that was a very big issue that we found, installation of water filters, so something as simple as, getting clear water, appointment of medical officers because of medical issues and regular medical care, and institution of prison development board, which was focused on looking at prisoners' needs, their rehabilitation, their restoration back into the society. So some of these aspects, this actually showed, this is one experience. We had similar other experiences as well in other states where we did the studies, but this was a very good traditional player, collaborative effort where we were able to champion the prisoners, their experiences, what we found in the system, the gaps in the policies, gaps in the implementations, and we were able to really convince the traditional players what's missing from there, the way it works, and not just prison. So this report, of course, covered other experiences of prisoners with the courts, with the police. We've covered a whole lot about custodial violence, the issues that they were facing when they were coming through the police to the prison. So that is a very good example that we have, how we can work together. And I think, and for me, like I've worked as a non-traditional player for a long time, and recently I've been consulting for some of the statutory bodies and government institutions. It's been significant how, the experience that I have of engaging with the people, knowing what it is, how I've been able to use that for the policy changes, and to be able to explain, why this policy isn't working. So a lot of times, the government comes out with a policy and then it doesn't work. And that's the understanding then you have to say, why isn't it working? And that's when you tell them, see, it's not working because it's not it's not, you're making policy by policy makers who don't understand the ground realities. So those policies will not work. You need to have a proper, top, bottom, top approach, which kind of, feeds back from traditional players, and non-traditional players help do that. You know, they are the ones on the ground. They are the ones who are the eyes and ears for the policymakers. You know, they are the ones who can really help, you know, kind of, translate those experiences, those needs, those challenges to policies. And that's, I think, where the role of traditional players is really important in the system. So, yeah, I think that's, my point to be made. Yeah.
Thank you, Madhurima. Thanks so much. Really emphasize on collaboration and how through collaboration we can come up with an intervention and solution that really answers to people's needs. Next, I will turn back to Judge Siriwat. In the first round, you told us about the victim-sensitive court handbook, which is very cool. However, I do recognize that having a great tool is one thing, but translating it into action poses another level of challenges. Can you tell us what specific measures are being taken to train judges and court personnel in Laos to effectively implement the principles outlined in the Victim-Sensitive Courts Handbook, and how do you envision these measures addressing potential cultural or systematic barriers that may hinder a people-centered approach in legal proceedings?
Thank you for your question. To address your questions regarding to the specific measures being taken to train judges and court personnel in Laos to effectively implement the principles around me to outline the principles first. The Victim-Sensitive Court Handbook set out 8 principles or indicators such as follows. The first one, safety and privacy of traffic victims. The second one is evidence and protecting. Third, interaction of judges and court personnel with victims and witnesses. The fourth one, information and services provided to victims, especially victims' rights are informed to victims as witnesses during the court trial, including the rights to compensation, information on court setting, arrangement, and on the trial processes. The fourth indicator, the fifth indicator is recovery of the victim's rights. That means justice coordinate with victim support and protections agencies to ensure to provide counseling, referral, and advice to support women, children, and families effectively by several different issues. Next, the medical and forensic services and children victims. The last one is victims with disability. The VSC guidelines was endorsed in 2023, and we have since provided training to judges in the criminal and juvenile chambers, as well as judge assistants across the country. This training is compulsory, and judge assistant must pass the course. The VSC principles are being integrated into the training curriculum of the Judicial Training and Research Institute of the People's Supreme Court. We have complete training judges in the criminal and juvenile chambers and just assistant in 2023 to 2024 period. To ensure that these principles are applied in their work, the People's Supreme Court has incorporated case studies and follow-up training, including on-the-job training, into the curriculum. Additionally, with the support from ASEAN Act, we have established a mentoring program. This program not only provides technical support to the judges and judge assistants, and will develop monitoring and evaluation framework in early 2025 to identify areas for implementing and ensure the application of new skills and knowledge on victim-centered approach. As the guideline is related news, especially for just in the provinces, ongoing training and continuous professional development are necessary. Therefore, interagency dialogue and meeting are setting and essential, particularly in regions within the high number of cases. So that's all. Thank you.
Thank you, Judge Siriwat, for sharing on how the guidelines set out in the Victim Sensitive Courts Handbook are brought to life in the courts of Laos PDR. This is also a great example that not only the handbook must be people-centered, but its implementation needs to be designed around the needs of the people implementing it as well. In this case, the judges through programs like mentoring support. For the last round, for the last speaker of this round, we will end it with Echo, who represents such important role in criminal justice system, the police. Oftentimes, at least in Thailand, the police are the first point of contact when people enter the criminal justice system. And you know what they say, first impression matters, right? Echo, can you please tell us what strategies can be implemented to ensure that the principle of people-centered approach are not only adhered to during interviews, but also integrated into broader organizational culture, thereby fostering an environment of trust and collaboration among all parties involved?
Slide number 4, please. Okay. In early 2023, I had opportunity to lead standard investigative interviewing room at Wonosobo Police Resort. Creating this room was a significant step forward. It is not just physical space, it represents a commitment to transparency and professionalism. The room was set up with equipment to document interview accurately and was structured to provide comfortable, non-intimidating to the interviewee. The established this room helped cultivate a culture within the organization where everyone is expected to be well prepared, transparent, and accountable. Officers understand that they have responsibility to uphold fairness, human rights, and this room serves as a constant reminder of the commitment. Many interviewees, including victim witnesses, have expressed a sense of relief and satisfaction at being treated with a respect and understanding. We can read in front of, they say comfortable, they say participatory, different from the past, talk out on time. When the interviewee answered the question in interview process, the interviewers must active listening and no interrupt. the answer. And they feel talk at on time. No pressure at investigative interviewing method. Why? In the beginning, I tell investigative interviewing is a method to prevent violence, manipulation, interviewing, using a interviewer at interview process. And next slide, please. We have a strategies to create it, to develop investigative interviewing at Indonesia. The first is create ecosystem of learning. There are 4 points about ecosystem of learning. The first is institutional effort, establishing structure to support the effective transfer of skill of the workplace. Developing tool for supervision and performance indicator. Providing essential facility to support training and implementation. The second is a training. Preparing comprehensive training material, including curriculum, module, handout, and audio-visual resource. Implementing a coaching system to enforce skills. The third is a human resource. Managing your human resource needs to support and sustain the program. And the last for ecosystem learning is research. Conducting ongoing research to refine and improve the investigative interviewing approach. Collecting and utilizing interview samples to inform the best practice. And the second strategy is about legal framework. To set up the legal framework about investigative interviewing is important, such as what has been done by UNODC. Make a manual on investigative interviewing for criminal investigation. It's very important to suggestion the high-level management about positive impact investigative interviewing for implementation investigative interviewing, and explain about stronger reason to finally implementing a people center. And the last, it's about collaboration with criminal justice system. We discuss about the result of investigative interviewing can be prove the crime in the court, and we will research with criminal justice system about development investigative interviewing. And for the last, in conclusion, adopting a people-centered approach in investigative interviewing has proven to be transformative by focusing on respect, rapport, practical application, and evidence-based method. We not only gather more accurate information, but also build a more ethical trust in justice system. The establishment of the standard interview room in Wonosobo is testament to our commitment to this value about transparency, fairness within the organization. The experience from Indonesia demonstrates that when we prioritize people in justice process, everyone benefit. Thank you for your attention. I would be happy to take any question. Thank you.
Thank you so much, Echo, for sharing with us how investigative interview created a transformational shift towards people-centered investigation and shared with us strategies to implement the methodology nationwide. I will now open to questions. I assume that there are a lot of people waiting for it. So for the last 15 to 20 minutes, I would like to open for Q&A. If anyone has questions for our panelists, please feel free to put your hands up, and our facilitator, we don't need mics, you guys have mics. Okay, yes. I think we will start with you since you had your question ready.
Okay. Thanks for the moderator. I just mentioned interesting about our senior judge from Philippines. Yesterday I saw your slide here, and like it's a newcomer for me locations. And so I want to ask you, can you add more information about the government policy on the regional trial court and the court system in Filipino? Could you explain, add more some information for us?
You want more information
Sure.
on the regional trial court?
Sure.
My court and the RTC 50, branch 53, these are special designated courts for drug cases solely. So there are courts of general jurisdiction, there are courts, a family court dealing with women and children. There are other courts, but the more important courts, because the bulk of the problem really, and that is not to put down the other courts, it's just that the bulk of the criminal cases would fall to the drugs courts. So the Supreme Court were, in fact, only recently the Supreme Court increased the number of drugs courts in Manila. From 7, we are now increased to 11 drugs courts, because we cannot just simply cope up because of the spillover from the Duterte administration. You could only imagine, because he stepped down he was president from 2016 up to 2022. And there's still a number of cases spilled over from that administration. And so the government and the Supreme Court decided to increase the number of drugs court. And we only deal with drug cases. It's a special court only for drug cases. And so, as I said, the problem is we're created as in the state of Texas in America, where I had my immersion program for drug rehabilitation. The drugs courts there, they do not conduct trial. We do conduct trial, and we also have to have this rehabilitation process. And yet we don't have a court social worker, and the Supreme Court did not give us additional manpower. That is why it is very hard. But hopefully, with the advocacies and prodding the justices of the Supreme Court, we might be able to get at least one social worker each, because we do need more manpower, because the job is just too much. Because can you imagine, the bulk of the criminal cases are drug cases, and then you have to do drug rehabilitation at the same time. Let me just clarify that, of course, we do not ourselves conduct the drug rehabilitation counseling. That is farmed out to the NGOs, non-government organization, farmed out to the faith-based organization. And I want to give credit to the USAID Renew Health program. You see, before the Dangerous Drugs Board came out with the Dangerous Drugs Board Regulation number 7 series of 2019, there was nothing. We didn't know what to do. But luckily, the USAID helped with the cooperation of the Philippine Psychological Society under Dr. Echanova. They came out with the program of rehabilitation, which they called KKDK in Tagalog, Katatagan Droga sa Komunidad. And that program was rolled out rather, even as a pre-release program inside the jails. So meaning to say, if a drug offender enters into plea bargaining and I'll just give him, okay, 6 months imprisonment up to 6 months and 1 day, so he has to wait for 6 months, but we have that program, the USAID with the group of Dr. Chanova, we launched the KKDK, the City of Manila Mail Dorm, and we had this program as a pre-release program. Drug offenders were undergoing drug counseling already, rehabilitation counseling prior to the release, which they will complete upon the release. And then they will go into the second phase of the rehabilitation program, which is the aftercare and the livelihood program. So basically, I understand in some countries, the respective judiciaries in some countries do not have the power to implement rules and regulation, rules of procedure. I do not know, and that it has to be by law. That's how I understood it. But in our country, we are lucky because our Constitution empowered the Supreme Court to come up with rules and regulation procedures in the courtroom, in the court. That's why the Supreme Court was able to strike down that Section 23 and allow again plea bargaining, and which led to the congestion of our jails on a nationwide basis. Thank you very much.
Thank you. Yes, please go ahead. Oh, I think it would be good to introduce yourself as well, so we get to know each other a little bit in addition to panelists. Sorry.
Good afternoon. My name is Intana Bupasawan. I'm a director of Association for Development of Women and Legal Education in Laos, PDR. I would like to ask a question to TIJ officers, as having known that the percentage of the female prisoners, 60%, compared to male, just only 20% in from 2020 to 2022. So, from my understanding, maybe the Thai women, they know their rights more, and then they practice or use over the rights, and then become the criminal. And so that's why the female prisoners are increasing more than male. So because of they exercise their rights too much, or because of the lack of understanding of the law, and then they abuse the law. Yeah, I want to clarify. Thank you.
Thank you very much, ma'am, for your questions. I think it's not only in Thailand that, this increase of the female prison populations by 60% over the periods of 22 years. This is a global average. And that has reflected upon many factors. Key driver was listed on the left. But ideally, if we look at the backgrounds of who the women are when they come into contact with the criminal justice system, you will know that majorities of women are low levels, have a low level educations, have a limited access to employment. So these are the groups that are convicted of minor offenses like property crimes, who steals just to survive. A lot of crime was rooted into poverty, the limited choices in life and the meaningful way to make a living on her own. So in Southeast Asia, we have seen the rising in the female prison population has linked back to the drug policy, which are really punitive. Vast majorities of women were involved in drugs by many factors. In Thailand, we have majorities of women who are in prison for drugs were then involved in drug for a small drug dealer, having a small drug in possessions. But the law was so punitive and disproportionately affect women who have backgrounds of poverty and no other economic means to make a living. So I don't think that women have more access to, legal aids or understanding their own rights, make them want to commit more crime. I think it was the other way around. It was the lack of access to proper education or social welfare services that's supposed to prevent women from involving in the criminal activities that was leading them to commit offense. Other forms of involvement, women's involvement in criminal acts was sometimes linked back to the gender-based violence. If you have heard about the battle women syndrome, and this happened to many women in prison, related to their history of domestic violence, being a victim for many, many years to their partners or their spouse. One day women try to stand up for their own and then end up in prison for a serious offense like homicide. So we have cases like that as well. So I think it's a mix of many factors, and I don't think that we can just pin down to just one factor.
Thank you so much. Do we have any more questions? Yes, Callum.
Yeah, thank you so much for the very interesting panel discussion. I'm interested in how you found aligning people-centered justice approaches with your organizational KPIs as well, and whether you find that this naturally aligns and naturally adds value, or do we also need to look at building out new KPI frameworks, monitoring and evaluation frameworks that are properly aligned with a shift in focus to people-centered approaches? Anybody can take this. I think it's probably relevant for everyone.
I can, yeah. I think as you know, MEL frameworks, they're becoming increasingly popular now, especially with the funders. And I do see that there is a mismatch between the KPIs looking more at system efficiencies rather than people's experiences. And I think there's a lot more there that needs to be done. Also because one of the gaps I've seen in MEL frameworks is they're basically developed by experts in MEL, but not experts in systems. And access to justice is not something that's very easily measurable. Most of the impact that we have, especially when we work on policy, is intangible. And then framing, parameters or KPIs which don't do justice to the work and the effort that people put in, that's been a little bit of a concern, where we do see that mismatch. And it's often that your MEL personnel and then your ground level workers, there is a face-off because of that, because the framework will show that the effort was not put in to come to these indicators, but the work that they've done was individual centric, right? And that probably was what needed to be done given the dynamism of access to justice work. So yeah, I think there's a lot still needing to be done to make your MEL frameworks more more people centric, to look at how maybe frame them from a person's perspective. As I said, the example I gave about the quality of legal aid. So if you look at it from a system perspective, your KPIs will be very different. But you look at it from a person's perspective, you'll actually have a very different set of KPIs to do that. Yeah.
Okay, one more question.
To address my question to Judge Taylor. Okay, I am also a judge in the Philippines, and I am a judge of a court of general jurisdiction, and I also handle drugs cases since there is no special drugs court in our province. Judge, I would like to ask your opinion about second-time offenders. An accused has already underwent plea bargaining, and then after the probation, recommitted. And a case again was filed in sometimes in my court, so I would know that he is already a second-time offender. Would you allow a second-time offender to enter again into plea bargaining? And second question, ma'am. In community-based rehabilitation, in my province, we have a problem because this is a project of the local government units. And most of the local government units in that area have no budget. They have to wait for like 50 enrollees before they will conduct a community-based rehabilitation. So in the meantime, our the rehabilitees supposedly are waiting when to start the rehabilitation program. And while they are waiting, their cases are still in my calendar because I need to monitor whether or not they have undergone their community-based rehabilitation program. What can be a solution to this, ma'am? Because we are in the far-flung province in the Philippines, northern Mindanao, and we do not have like the UN or any other organization that might be able to help, or any NGO that might be able to help whoever is in charge or mandated to conduct the community-based rehabilitation program. Thank you, ma'am.
Okay, I will answer the question in reverse. You see, your problem is not unique in your province. We also experience these problems, but we are able to cope with the help of NGOs and faith-based organizations because they were allowed under the Dangerous Drugs Board Regulation number 7 series of 2019 to act as service providers. Luckily, in the city of Manila, we have Sanlakbay, or it is a group under the wing of the Catholic Church, and even the police had their own mindset, it's a group conducting, police officers conducting service providing counseling programs for drug offenders. So, in answer to your question, the problem really is whether or not your city or your province is willing to spend. And by spend, I mean hire more doctors to conduct routine drug dependency tests, because that's the first line of defense. Because without the result of the drug dependency test, we cannot even determine what is the level of addiction. And to whom are we going to send what intervention program? That is really the problem. That's why I was even talking with one of our colleagues here from the Asian Asia Foundation. You know, I'm trying to be proactive on how we can expand and solve this problem. And I even hired a legal researcher, and I told her I don't need a legal researcher, I need a drug rehabilitation SAR. That's what you're gonna be. I told her that. But that's true. Because I'm really focused on the rehabilitation process. That's why I think we have to talk to our governments, our local governments, national government, require, with the help of the United Nations, the Asian Development Bank, the ASEAN, and all the foreign organizations to really persuade the government to require the local governments to spend a portion of its internal revenue allotment to drug rehabilitation. Because the problem with the cities and the municipalities and the provinces is the judges are willing. You know that. The judges they do everything, spend their own money. But the problem is the local government itself, not the national government, because the national government, luckily, the president's focus and priority is drug rehabilitation. But of course, these rehabilitation sessions, counseling sessions, will have to be farmed out to the local anti-drug abuse councils and offices of each province and cities, and that's the problem. Many of them don't want to spend on the drug offender to rehabilitate them. That's why we have to have a massive information campaign. And don't vote for officials who will not spend for the drug addict. So what I'm trying to say is there is a lot to be done. That's why if you're here, go to the members of the Asian Development Bank, you might want to spend into the program of the city, your province. So you have to think outside the box because the resources in the Philippines are not that good. That's why they even had to farm out, and they accredited faith-based organizations and non-governmental organizations to do the job for them. So, good luck, ma'am, and good luck to me. Now, with respect to the question, it's like this. I do understand that the Supreme Court, as we know, issued this latest regulation circular that if there is recidivism, habitual delinquency, then technically they're not allowed to enter into a second plea bargaining, yes? But I'm always, I have this positive attitude. I was hoping to be able to talk to one of the Supreme Court justices, Justice Philomena Singh, who's supposed to be here, but unfortunately she had to cancel. But you see, if we have to be scientific, all the scientists, all the UNODC, the World Health Organization, they all say the drug addict, even if they go into rehabilitation, will always go into relapse. They will always do that. But do we stop? Of course not. That's why in my food cart business, we execute a deed of conditional donation. The condition is, okay, after 1 year, I will give you the food cart. I will not get it back from you, provided you don't test positive for drugs for at least 6 times. Because they will go into relapse, as any doctor engage in drug rehabilitation. And do we stop just because they go into relapse? So what will happen? No, we cannot give up. If we give up, we are all lost, because these are, well, I don't have any family member who is a drug addict, but literally these are your family members of society that we have to take care of. And the more that they do go into relapse, the more that we should be more understanding and try to go beyond what is humanly possible because, so many drug addicts go into suicide, and you know that, and you wouldn't want that. That's why I am well aware of the circulars issued by the Supreme Court, but also we can argue respectfully with the justices for them to amend that the latest set of circulars, that we have to give them another chance and to go into plea bargaining again, because as we all know, Republic Act 9165 is a very defective law, and for all my colleagues here, when you are in the process of enacting a law or drafting a law, you have to consult the judges. And when they drafted in the Senate, in the Congress, RA 9165, not a single judge or justice of the Supreme Court or the Court of Appeals were invited by Congress, and that was another big mistake. That's why that law is a very flawed law. But anyway, ma'am, let's think positive. Maybe we can persuade the justices to think twice. That's my take on that. Thank you very much, ma'am.
Thank you so much, Judge Taylor. I hate to close this session when the Q&A is so vibrant. I hope you will continue these conversations at the networking session this evening. Thank you all for joining us today for this insightful panel. As we conclude our session, let's reflect on key themes that we've explored. We recognize the urgent need for a transformative shift in our criminal justice systems, prioritizing individual needs over institutional objectives. Our panelists shared valuable insights on how a people-centered approach enhances accessibility, fairness, and responsiveness within the justice framework. They also remind us to think about people. Who are the people that we're talking about? And not just the target group, but also other stakeholders involved around them. We also discussed the critical roles of various stakeholders, including police, judges, and civil society organizations in implementing this approach. The successful initiatives highlighted today demonstrated how tailored services can address the unique experiences of diverse communities and how collaboration among stakeholders can make that happen. I want to express my gratitude to our panelists for their expertise and contributions. Your insights have inspired us all to envision a more inclusive and equitable justice system. Thank you once again for your participation. Let's carry the momentum from this discussion into our future endeavors as we strive for a justice system that is truly centered around people. And can I have a round of applause for all of our speakers as well? Thank you. Networking reception is on the second floor where the coffee break was, and see you there.